We want to start tonight with big news in the Doomsday couple case. Chad and Lori Daybell, accused of murder. There they are. Much different times back then. They've been locked up for a long time waiting for their trial to start. And we had some important developments today in a hearing that sort of just popped up. And it all has to do with where is this trial going to be? Where will the jurors come from? And will the jurors be able to go home at night during the trial? Big issues that have to be decided. And there's a little bit of a history to this issue for me personally in cases that I've covered through the years. When you talk about sequestration, which is, the jury comes to work and they don't go home until there's a verdict, right? They go back to the hotel. They can't talk to anyone. They can't watch the news. They take the cell phones away. They cut out pieces of the newspaper that they can read if they're still reading newspapers these days. Careful what they can watch on television. Maybe it's just Netflix, or maybe it's just a DVD. A lot of restrictions. What happens in those cases is the jury really gets hyper-focused on the case, which is a good thing, right? You don't want them distracted by anything else happening. But something else happens as well. You get some really interesting verdicts that are somewhat unexpected, at least for me they were, like O.J. Simpson's sequestered jury, Casey Anthony's sequestered jury. I think George Zimmerman's jury was sequestered as well. Wait, not guilty, not guilty, not guilty. If I'm the prosecutor, I don't know if I want the jury sequestered necessarily. Something happens to them in that process. Anyway, big issue today inside the courtroom. There was a hearing. You had John Pryor was there, the judge was there, Rob Wood, the prosecutor was there. Let's take a look.
We've got a change of venue hearing set for 2 days. It's been scheduled for some time. There's been some additional filings, and in the interest of judicial efficiency and economy, I just wanted to discuss with counsel a few issues. I would note there were some filings that went into the case today by the state, a motion to sequester the jury and a response in support of the defendant's motions to change venue. Well, it was a response to, not in support of, a response to the motion to change venue.
While we do believe we can pick a fair and impartial jury in Fremont County or Madison County, we're not, for purposes of avoiding appeals, we're not going to object to a change of venue, but we are asking the court to follow statutory procedure that's allowed to take that jury and bring them back to Fremont County. We have a lot of reasons to do so. And so part and parcel of that is a sequestration of the jury helps provide for the fairness of the jury trial to both sides.
They're agreeing to a change of venue. So now the issue is a two-pronged issue. The venue change, they're agreeing to change venue. At this point, the court has to decide where the case gets changed to and what location. So my feeling is simply this, is the court can hear the evidence. I've already relayed to the court that evidence is going to be relatively brief, assuming I don't engage and there's no issues with the evidentiary issues that I don't anticipate there being, but it should be relatively brief, less than a half a day for, I think, both sides. And at that point, if the court wants to hold off and not make a decision until they hear Mr. Wood's argument on the other matter, but to put me in a position, Judge, for a hearing that is of significant importance to everyone, and say 2 business days before the hearing, by the way, you're now going to have to spend the rest of the weekend preparing for your argument on moving it and bring juries in and from another place or another location, and I'll have to address that legal issue in a short period of time. Obviously, Mr. Wood and Ms. Blake's brief was well prepared, and it took them some time to put that together. That 17-page brief did not take a day or two to put together. They've had that for a significant amount of time. And with all due respect, everybody, Judge, it's a little bit of grandstanding, it's a little bit of game playing, and I don't appreciate it. So I am vehemently
Mr.
opposed.
Pryor, I think you're maybe jumping to a conclusion about game playing and grandstanding there. These things happen sometimes, and this is the reason why I've called a status conference to determine what we're doing Tuesday, basically. That's the questions.
For purposes of the record and with all due respect to the court's prior ruling, we do not feel it's appropriate to be having a hearing that affects the trial rights of Mrs. Vallow Daybell and not have her be present. Chad Daybell has waived his right to a speedy trial. This whole hearing shouldn't be happening. Now, obviously, we'll defer to the court. That's the court's decision, and we'll follow whatever the court does. We had a hearing just last week on that issue. So, quite frankly, Your Honor, we've been working on moving down the path that we feel is going to lessen appeals and which protects both the defendant's rights. I think it's absolutely appropriate, and where it dovetails into the arguments for publicity, pretrial publicity, and publicity of and jurors being affected by the publicity, I think it's absolutely appropriate.
I'll need some data to look at. I don't know how much it could be proposed to cost to sequester jurors for an extended time versus costs of security and sheriff's fees may be incurred if Mr. Daybell is transported to another jail, and those costs are passed on to Madison and Fremont counties. So I appreciate arguments will be made on that. The motion to sequester, I'll grant motion to shorten time so that can be heard and argued on the Tuesday hearing. And then again, Mr. Pryor, if you feel like that's disadvantaged you because of the timeliness, I may allow additional time for a response. Criminal Rule 21A, I have to make a finding that I'm satisfied that a fair and impartial trial cannot be held in the county. And so just because both sides say that, I may well agree, but I want to know what that's based on. And I think that should be part of the focus of your arguments on Tuesday if you do have an agreement on that issue.
I'll be honest with you. If I was the prosecutor, I wouldn't be arguing for sequestration. I mean, the history is out there for these big trials. Sequestered juries come back and say not guilty. And that's not what you want as a prosecutor, right? All right, let's bring in our think tank tonight. Maybe they disagree with me. I mean, is it possible that they could disagree with me? Joining us tonight in the Bronx, New York, criminal defense attorney Renee Hill. In Houston, Texas, criminal defense attorney Carmen Rowe. And in Atlanta, Georgia, criminal defense attorney, law professor at Emory University and Georgia Innocence Project board member Molly Palmer. Great to see everyone. Renee, do you want this jury sequestered as a defense attorney? Because honestly, as a prosecutor, I don't want it. Something happens where they don't see, I don't know, they don't see the forest through the trees or the trees through the forest, however that saying goes. They are just like this, and they come back with these verdicts I don't understand.
I don't particularly care for a sequestered jury myself because I feel like the jurors, they want to get home. And because they miss their families and their lives, they want to get out of there as quickly as possible. And sometimes they will rush to a judgment. They will compromise on a judgment just to get out of that room. And that is not always good for the defense. Although these high-profile cases that you talked about did result in acquittals, I think
it was
that
very
there
good
are
for the
a
defense
lot.
in those cases.
It was very good for them. And I had a case where it was very good for me as well. And it was a homicide case. And they were out 4.5 days.
See what I mean?
And they acquitted.
Sequestered.
However,
and they said
that
not
was very
guilty,
long
right?
ago. They did. But I think that primarily you are going to have jurors that will rush to get out and rush to convict more than they
The
would
proof
to
is in the
acquit.
results. I mean, your guy did it, and he was found not guilty, Renee.
Oh, you don't even know what the case is. No, he did not.
I'm only kidding. Carmen Rowe, am I onto something here? Because now I've got 3 big cases, Renee's case. These juries get sequestered, and something crazy happens to them.
You know, Vinny, I think you're onto something, but I also think what you said is really important. Look, if these jurors are going back there and not being influenced by the public like Chauvin's trial was, and these issues do not present themselves to these jurors, and they are as focused as you say because they're sequestered, isn't that the better justice system that we're looking for?
I'm looking for, jurors that when a mother does nothing for 31 days and her child is dead and it smells like death in the trunk of her car and she lies about going to work and she makes up a nanny and she doesn't tell anyone. I don't know. I think they lose common sense, Molly Palmer. I think they lose their ability to just apply common sense to a situation and put two and two together.
Well, I mean, I think what I think about when I consider the idea of sequestration is something that's almost similar to what we see in solitary confinement. When you're that isolated, it affects your thinking. So now every case is going to be different, but a defense lawyer is considering whether that type of mentality is going to help their client or hurt their client. But when you're totally isolated away from your friends and family, that changes your mind. And I think what we see is, like my esteemed criminal defense colleagues have pointed out, there is this fixation on what's before them and not the extraneous surrounding details. But there's also a tendency to have groupthink, and also juries become more contentious when they have nothing else to do besides kind of go back and forth between each other. So it's a case-by-case situation. But I think you are onto something, Vinny, that juries do acquit.
I'm trying to come up with a sequestered jury that said guilty. Please, folks, direct message me, email me, let me know about the big trial where the jury was sequestered and they came back and said guilty, because I don't remember one off the top of my head. We have more developments tonight, by the way, in the case involving this Doomsday couple. The Maricopa County Medical Examiner, that's in Arizona, not in Idaho, but in Arizona, has now ruled on the death of Charles Vallow, who was the husband of Lori Daybell before she married Chad Daybell, the prophet. She was married to Charles Vallow for 12 years. They were raising these two children together, but he was shot and killed by her brother. Today we found out the cause of death was multiple gunshot wounds, a gunshot wound to the chest, a gunshot wound to the abdomen. And all of a sudden, I'm looking at this now, and this looks a lot more like murder than self-defense to me, Carmen Rowe, when the allegation by Lori's brother was self-defense. He was coming at me, shoots him once, he hits the ground, shoots him again when he's on the ground. Looks a lot more like murder.
Benny, they got some explaining to do, and this is just one more thing that's going to be hard to get around. I mean, they got kids in the backyard. They got this guy who's now, we see clearly been shot so many times. None of this makes sense with any of the explanations that have been given. And this is going to be a fascinating trial to watch as we unfold these types of extraneous issues that are no doubt going to play significant roles, if not center position in this trial, and I can't wait for it to get started.
That's Alex Cox on the curb there, Molly Palmer. That's just moments after he shot and killed Charles Vallow, and today we found out shot him twice in the chest and the abdomen. Waited a little while, then called police, and then showed police the little boo-boo on the back of his head. He's dead now. He's dead now, and there's clear evidence that he's killed at least one human being. Do you think at trial Chad Daybell points the finger at Alex Cox?
I think that that's certainly a possibility, Vinny. I mean, it's always convenient for the defense when you have another deceased person, not your victim, but another deceased person that you can point the finger at, because that person, of course, cannot come to court as a witness and say, absolutely, that's not how it happened at all. So I've been thinking about Mr. Cox a lot and the fact that he's deceased. And so certainly we can't go back and undo the self-defense claim because, you know, he cannot tell us exactly what happened or clarify why there were multiple gunshot wounds. But I think he's going to play a very significant role in this upcoming trial.
Yeah, I think he's an obvious villain and is going to loom large in the courtroom, even though he won't be there. And if he was there, he'd be one of the co-defendants in all of this.